All right, I'm going to give you a few pointers for the AP. Then I'm going to give you a general summary. And then I'm going to talk mostly about search and seizure and exclusionary rule. First, you need to be able to distinguish civil liberties from civil rights. Civil liberties are constitutional protections an individual has against government action. Many times, civil liberties stem from the Due Process Clause of the 14th Amendment. Civil rights protect groups who have faced historical discrimination. Civil rights protections often arise from the Equal Protection Clause of the 14th Amendment. This is also a good time for you to review the Bill of Rights. Civil liberties stem from protections granted in the 1st, 4th, 5th, 6th, 8th, and 9th Amendments. Fundamental rights in the Bill of Rights have been selectively incorporated through the 14th Amendment's Equal Protection and Due Process Clauses to protect individuals against state action. This process began with the Supreme Court's decision in Gitlow v. New York in 1925. Selected incorporation has appeared frequently on the AP exam. In District of Columbia v. Heller, the U.S. Supreme Court ruled that the Second Amendment protects an individual's right to own a firearm. Read the case if you can. Look it up. What's the extent to which it's possible for the government to regulate guns? That's a possible question. Okay. Make sure that you look at all the cases, the landmark cases that are in the inset in the chapter. In 2008, Congress passed the Foreign Intelligence Surveillance Act, that goes FISA, allows the government to intercept foreign communications with people in the United States, provided a FISA court approved. Some people believe FISA is a violation of the Fourth Amendment's protection of privacy. Parts of it have been curtailed. Without probable cause, you need a warrant. Okay. Okay, to summarize, we're talking about First Amendment rights. During the 1960s, the Supreme Court began broadening the way in which constitutional rights are interpreted. In the area of free expression, the First Amendment now guarantees virtually any form of communication, with several exceptions. First, libel, false statements that harm a person's reputation, remain unprotected, but it has been made more difficult to prove in certain situations. Public figures must prove actual malice. A defamed person must establish that a statement was uttered either in the knowledge that it was false or with reckless disregard for its accuracy. In 1991, the court went so far as to exclude fabricated quotations from the definition of libel, as long as the misquote did not materially change the meaning of what was actually said. Obscenity is the second form of speech, not protected under the First Amendment. The problem is that it's not entirely clear what constitutes obscenity for constitutional purposes. The absence of a precise definition has led to anomalies, as when the rap group 2 Live Crew was acquitted of obscenity in Broward County, Florida, despite the conviction of a record store owner for selling albums in the same county that contained the same songs. The court's current Miller test of obscenity hardly articulates a satisfactory standard for banning a particular kind of speech, but we do need to know all three parts to the Miller test. The third variety of speech, rendered at least partially unprotected under the First Amendment, is called symbolic speech. Expression of this kind typically involves some type of illegal behavior designed to communicate an idea. Speech expressed through conduct is frequently referred to as speech plus, the plus being the conduct. Activities considered symbolic speech include demonstrating and marching, pouring blood on Army recruiting records, wearing a black armband as a protest, the Tinker case. Such speech is not wholly without constitutional safeguard, but is entitled to a lesser degree of protection. In the words of Justice Arthur Goldberg, we emphatically reject the notion that the First and 14th Amendments afford the same kind of freedom to those who would communicate ideas by conduct as these amendments afford to those who communicate ideas by pure speech. That case is Cox v. Louisiana, 1965. The Supreme Court's position in determining whether behavior is considered symbolic speech can be looked at in the following ways. 1. The speaker must have an intent to convey a message. Right? The audience must be likely to understand the message. That's 2. And 3, the speech must make a contribution to the body of knowledge. The court has allowed the government more latitude in regulating the conduct associated with symbolic speech than the expressive content itself. Thus, the government can punish the burning of a draft card as a form of protest because its goal in making the regulation is not to suppress the idea being communicated, but to defend the nation's security. On the other hand, the government cannot forbid the burning of the American flag as a form of protest because the behavior does not threaten a breach of peace, making the suppression of an idea the only purpose behind the law. The fourth type of expression lacking complete constitutional protection is commercial speech. At first, the Supreme Court placed commercial speech entirely outside the First Amendment in a case in 1942, but eventually provided it with limited coverage. Advertising, according to Justice Blackmun in Bigelow v. Virginia in 1975, is, quote, not stripped of all First Amendment protection, unquote, so long as it is truthful and of value to the public. It is only when advertising is either deceptive or involves an illegal or harmful product that commercial speech is subject to suppression or regulation. The religion clauses of the First Amendment are caught in a similar web of confusion. The Free Exercise Clause was initially treated as a stepchild of the Free Speech Clause. Until the 1960s, cases raising free exercise claims were typically decided on the basis of principles of free speech. In Sherbert v. Verner in 1963, the court gave the Free Exercise Clause an independent identity and required the government to provide a compelling interest to justify any burden on the practice of religion. The confusion enters through the manner in which this tough standard was implemented, with the court almost always deciding against the free exercise claim. In 1988, a fatal blow to Sherbert was rendered in Employment Division v. Smith, in which the compelling interest test was held inappropriate to criminal conduct. People can no longer rely on the Free Exercise Clause to exempt their behavior from a law of general applicability that is not designed as an attack on a particular religion. In response to Smith, the Congress passed the Religious Freedom Restoration Act, 1993, which was explicitly intended to displace Smith and reinstate Sherbert's compelling interest test. In City of Bourne v. Flores, 1997, however, the court ruled that the Religious Freedom Restoration Act exceeded Congress's authority. The opinion delivered by Justice Kennedy noted that Congress could properly enforce the constitutional right to free exercise of religion, but that such enforcement could only be preventive or remedial. The RFRA, however, involved the Congress in defining that right. As such, it contradicted the separation of powers. Second, the RFRA was described as wildly out of proportion to a supposed remedial or preventive object. All told, RFRA is a considerable congressional intrusion in the state's traditional prerogatives and general authority to regulate for the health and safety of their citizens, and is not designed to identify and counteract state laws likely to be unconstitutional because of their treatment of religion. Thus, the RFRA also contravened federalism. The Smith standard has therefore been reinstated, though legal scholars speculate about what additional actions Congress might take. Many of the same problems haunt the Establishment Clause, which Jefferson argued is intended to erect a wall of separation between church and state. It is generally agreed that the clause forbids the establishment of an official religion and restricts the government from becoming involved in religious matters, even on a non-preferential basis. Beyond that, the meaning of the Establishment Clause remains elusive. The court in Lemon v. Kurtzman articulated a three-part test to determine violations of the Establishment Clause. 1. The statute must have a legislative purpose that is secular. 2. A government policy must have a primary effect that neither advances nor inhibits religion. And 3. The government policy must not result in an excessive entanglement of church and state. These tests have produced a great deal of uncertainty to the point where the Supreme Court itself has strayed from invoking the Lemon standards. In recent years, the Court has adopted a compromise position of sorts, allowing some funding of religious programs as long as the government remains neutral in the process. In Zellman v. Simmons-Harris, 2002, the Supreme Court upheld a program whereby the government gave parents vouchers for school-aged children that they could then redeem at a school of their choice. Although parochial schools were included in the program, the court concluded that the Establishment Clause had not been violated because the educational choice was directed by the parent, not the government. Thus, it ruled that a law is presumed to be constitutional as long as the government did not inhibit or promote religious affairs. Now we need to look at due process. Due process follows the 5th and the 14th Amendments. It protects individuals from the arbitrary power of the state and safeguards the legal rights of individuals. There are two types of due process. One is procedural, which has to do with laws that make sure laws are administered in a fair manner. It limits how the government does things, implements things, or acts, such as in a court of law. Substantive means the laws have to be reasonable. It limits what laws the government may establish. Always remember your balancing tests, especially like in the Shepard case, and always remember, that sometimes the problem can be both procedural and substantive. The two things we really need to discuss are the exclusionary rule and search and seizure. I've added a link here to the Annenberg videos, and I would suggest that you use it. Okay. The exclusionary rule refers to what evidence can be used under the 5th and 14th Amendment in a trial. In other words, you're going to be challenging the use of evidence in a trial. Is it tainted? Is it fruit from the poisonous tree? These are questions that have to be asked. There's also a direct relationship with search and seizure has a direct relationship to the rights of privacy. Most nations let all evidence into trial, later punishing any police misconduct after it's over. The United States doesn't do that. It excludes improperly obtained evidence from trial. The exclusionary rule means that evidence gathered in violation of the Constitution cannot be used in a trial. It implements the 4th Amendment, freedom from unreasonable searches and seizures, and the 5th Amendment, protection against self-incrimination. Your precedent case here is Mapp v. Ohio, which is a 1961 case in which the Supreme Court began to use the exclusionary rule to enforce a variety of constitutional guarantees. I will continue in Part 2.